Picture this. You're sitting on a jury, literally holding a person's life in your hands. An expert witness takes the stand, looks right at you, and confidently swears that a bullet found at the crime scene is a 100% undeniable match to the suspect's gun. It's a heavy moment, right? That's a kind of definitive evidence that closes cases for good and sends people to prison. But what if I told you the hidden numbers behind all that confidence? Would you still vote to convict someone if you knew the foundational science backing up that testimony was actually failing its own stress tests? Seriously, weigh the immense gravity of that courtroom moment against the pretty shocking reality of how these experts actually perform when we put them to the test. Well, a recent proficiency test of forensic firearm examiners just delivered a bombshell result that completely shatters the whole myth of infallible pattern matching. As this critical examination in the Proceedings of the National Academy of Sciences points out, a 20% false positive error rate isn't just some minor statistical hiccup. In a courtroom, it dramatically cranks up the risk of wrongful convictions while potentially letting the actual perpetrators just walk free. Section 1. The shocking 20%. Let's look at the specific numbers that sparked a wave of panic within the forensic community. So, during the 2023 Collaborative Testing Services, or CTS, Firearms Proficiency Test, the false positive error rate for matching fired bullets hit an alarming 20%. To put that into perspective for you, the FDA has literally recalled life-saving medical devices over a 0.022% failure rate. Yet here we are, staring down a 20% failure rate in a field that regularly decides human freedom. And this breakdown brilliantly illustrates the full scope of the problem. When we look at the aggregate responses for the really challenging test items, those false positives were only a fraction of the story. Examiners only made a correct elimination 32% of the time. And incredibly, nearly half of all decisions, 48%, fell into this murky, inconclusive gray area. Section 2. Anatomy of a forensic test. How exactly are we interrogating the mechanics of these tests? To understand how these devastating errors happen, we got to look at how the specific CTS test was actually designed. Examiners were given 5 items in a match-to-sample setup. They had one known sample bullet, and they were asked to compare 4 questioned bullets against it. But here is the massive trick. Absolutely none of the questioned bullets were fired by the sample gun, meaning any examiner claiming a match was objectively wrong. Now, take item 4. This was designed to be an absolute gimme, an easy out-of-class elimination. It was fired by a completely different type of gun barrel. We're talking polygonal rifling versus conventional rifling. In the forensic world, that is a massive, glaring difference. It is literally like asking a professional driver what a red light means. Yet somehow, 1.5% of highly trained examiners still failed to correctly identify it as an elimination. Section 3. The illusion of perfection. If examiners are failing the most basic elements of these baseline tests, how have historical error rates looked so artificially low for decades? Well, the answer usually lies in something called consensus scoring. Instead of grading an examiner strictly against absolute objective physical reality, ground truth, test administrators often rely on consensus scoring. Basically, they're grading examiners on a curve based on majority rules. And it creates this incredibly dangerous paradox. Ground truth relies on the absolute fact that the bullets do not match. But under consensus scoring, if the majority of examiners just guess inconclusive, then inconclusive officially becomes the correct answer on the test. That means an examiner can be deemed totally correct just because they agreed with the crowd, even if their conclusion completely contradicts the physical reality of the evidence sitting right in front of them. Section 4. The inconclusive gray area. Remember that massive 48% chunk of inconclusive answers? This is essentially the most pervasive hiding spot for uncertainty in forensic science. When nearly half of all responses are just inconclusive, it becomes completely impossible to know if the examiner is practicing appropriate scientific caution because the evidence is degraded, or if they simply lack the skill to interpret perfectly adequate test materials. The Association of Firearm and Toolmark Examiners actually dug into this and found a really concerning root cause. Confusing laboratory policies and inconsistent training are actually leading some examiners to just guess. Some reported they were terrified of submitting inconclusive results because they thought they'd be penalized by their lab's specific quality assurance manual. So instead of doing strict science, they just guessed the answer they felt they were nearest to, just to avoid getting in trouble. Section 5. Bias in the lab. Beyond the mechanics of the test and those confusing lab policies, We have to look at how psychological biases and real-world expectations actively contaminate casework. In the real world, the expectation of finding a match is incredibly powerful. Take automated investigative systems like NIBIN. When it generates a potential lead linking ballistic evidence, the system explicitly instructs the human examiner to confirm the match. Just think about that wording. It plants a massive cognitive bias, expecting a positive result before the examiner even turns on their microscope. And this bias just compounds when we look at the non-blind verification pipeline used in lots of labs. Here is how it works. Step 1. The first examiner makes a subjective match. Step 2. A second examiner reviews the evidence, but they already know exactly what the first examiner concluded. This isn't an independent check at all. It's an echo chamber. It reinforces errors and falsely gives courts the illusion of independent corroboration, when in reality, it's just two people nodding in agreement. Section 6. Reforming forensic science. Look, a 20% false positive rate isn't just an academic failure. It's a systemic crisis that demands immediate structural reform. We just can't keep relying on overstated forensic certainty. The discipline absolutely must adopt true scientific rigor. Labs need to abandon non-blind verification immediately. They have to implement truly blind proficiency testing that mimics the actual difficulty of real casework. They need to stop relying purely on consensus scoring to artificially inflate their success rates. And they must exclude task-irrelevant contextual information that biases examiners. Honestly, the whole field needs a major cultural shift toward epistemic humility about the actual limits of human visual comparison. Ultimately, this leaves us with a critical question. If the science itself isn't blind to bias, how can justice be? The next time you hear an expert claim absolute 100% certainty in a courtroom, you really have to ask yourself, are they reporting the objective scientific truth, or are they just agreeing with the consensus?